The federal courthouse in Washington stood imposingly against the gray January sky as crowds gathered on the steps despite temperatures that hovered just above freezing, their presence a testament to the historic significance of the proceedings scheduled to unfold inside Courtroom Number 6. The case before Judge Tanya Chutkan concerned constitutional challenges to a sweeping executive order that purported to restrict birthright citizenship, specifically targeting children born in the United States to parents who were unlawfully present in the country at the time of birth. The executive order represented an unprecedented attempt to reinterpret the 14th Amendment's citizenship clause through administrative action rather than constitutional amendment, claiming that the phrase "subject to the jurisdiction thereof" excluded children whose parents owed allegiance to foreign nations or who were present in violation of immigration laws. Civil rights organizations had immediately filed suit, challenging the order as unconstitutional on its face, arguing that the citizenship clause meant what it said, and that over a century of precedent established that birth on American soil conferred citizenship regardless of parental status, with narrow exceptions for children of foreign expatriate, diplomats, and enemy soldiers during wartime. Judge Tanya Chutkan had developed a reputation during her decade on the federal bench as a meticulous jurist who demanded rigorous legal reasoning and showed little patience for arguments that relied on rhetorical flourishes rather than careful textual analysis and historical evidence. Appointed by President Obama after a distinguished career as a public defender and private practice attorney specializing in white-collar criminal defense, she had issued numerous high-profile rulings that demonstrated her commitment to applying law as written without regard for political consequences or popular opinion. Her approach to constitutional interpretation emphasized fidelity to text and original public meaning, while recognizing that the Constitution's broad language often required applying enduring principles to circumstances the framers could not have anticipated. She had ruled against both Republican and Democratic administrations when she found their actions exceeded statutory or constitutional authority, earning respect from legal scholars across the ideological spectrum, even when particular decisions generated intense political controversy. The hearing today would focus on the government's motion to dismiss the constitutional challenge on grounds of standing, ripeness, and political question doctrine, procedural arguments that, if accepted, would prevent the court from ever reaching the merits of whether the executive order violated the 14th Amendment. Representative Jasmine Crockett sat in the gallery section, typically reserved for members of Congress and other government officials with interest in pending cases. Her presence unusual but not unprecedented, given that she had filed an amicus brief on behalf of the Congressional Black Caucus and the Congressional Hispanic Caucus, arguing that the executive order threatened fundamental constitutional principles that had been central to Reconstruction and to subsequent immigration policy debates. She had spent weeks working with constitutional historians and immigration law experts to prepare a brief that situated the citizenship clause in its historical context as a repudiation of the Dred Scott decisions holding that Black Americans could never be citizens, and that traced how birthright citizenship had functioned as a mechanism for national unity and immigrant integration throughout American history. Her research had uncovered extensive evidence that the framers of the 14th Amendment had understood the jurisdiction language to have a narrow meaning, excluding only children of diplomats and invading armies, not to create a broad exception for children whose parents were unauthorized immigrants or temporary visitors. The brief also documented how eliminating birthright citizenship would create a permanent underclass of stateless individuals born on American soil who would lack the basic protections and opportunities that citizenship conferred, fundamentally altering the character of American society in ways that the executive branch could not accomplish through unilateral action. The courtroom filled rapidly as the scheduled hearing time approached, with immigration attorneys who represented clients whose children would be affected by the executive order occupying the front rows alongside Justice Department lawyers who would defend the administration's position. Legal observers from major news organizations and civil rights groups filled the remaining seats while overflow crowds watched on monitors in adjacent courtrooms that had been opened to accommodate public interest. Judge Chutkan entered precisely at the designated hour and called the court to order with the efficient formality that characterized her courtroom management style. She began by outlining the issues before the court and establishing time limits for each side's presentation, making clear that she expected focused arguments, addressing the specific legal questions she had identified in her pre-hearing order, rather than broad political or policy debates about immigration enforcement. The plaintiffs-led counsel approached the podium and began his argument by emphasizing that the constitutional challenge presented straightforward questions of law that required no factual development and that the government's threshold objections were pretextual attempts to avoid judicial review of plainly unconstitutional executive action. Judge Chutkan interrupted early in the presentation with a question that revealed her characteristic focus on doctrinal precision and her insistence that advocates address weaknesses in their positions rather than simply advancing their strongest points. She asked whether the plaintiffs had adequately alleged concrete and particularized injury, given that the executive order had not yet been implemented and that government officials had suggested enforcement would begin with prospective births rather than attempting to revoke citizenship of individuals already born. Her question probed the standing doctrine's requirement that plaintiffs demonstrate actual or imminent injury rather than speculative future harm, and it signaled that she would not simply accept broad assertions about constitutional violations without careful analysis of whether the plaintiffs had the legal right to bring their claims. The attorney responded by explaining that the organizational plaintiffs included hospitals and clinics that would be directly affected by implementation of the order because they would be required to verify parental immigration status before issuing birth certificates, that individual plaintiffs included pregnant women whose children would be denied citizenship if born after the order took effect, and that the threatened injury was sufficiently imminent given the administration's stated intention to implement the order within weeks. Judge Chutkan pressed further, asking whether the injury to organizational plaintiffs was truly concrete or merely reflected disagreement with government policy, and whether pregnant women could establish standing based on potential future harm to children not yet born. Her questions were not hostile but rather reflected the kind of rigorous scrutiny she applied to all cases regardless of her personal views about the underlying policy. The attorney struggled somewhat to articulate responses that satisfied her doctrinal concerns while maintaining that the case presented urgent constitutional questions that required immediate judicial resolution. The exchange continued for several minutes with Judge Chutkan, identifying potential weaknesses in the standing analysis, and the attorney attempting to distinguish precedents she cited or to explain why those precedents did not control. Legal observers watching the exchange began to worry that Judge Chutkan might dismiss the case on procedural grounds without ever reaching the constitutional merits, an outcome that would allow the executive order to take effect while litigation over justiciability questions wound through the appeals process. The government's attorney then took the podium and began arguing that the case should be dismissed, not only for lack of standing but also because it presented a non-justiciable political question about the scope of citizenship, that the Constitution committed to the political branches, rather than to judicial determination. He cited historical examples of Congress exercising authority over naturalization and immigration to suggest that citizenship determinations were inherently political rather than legal, and he argued that judicial intervention would improperly substitute court judgment for executive interpretation of constitutional text. Judge Chutkan interrupted with evident skepticism, asking whether the attorney seriously maintained that constitutional challenges to executive actions affecting fundamental rights presented political questions beyond judicial review, and whether his position would preclude courts from ever reviewing executive branch constitutional interpretations regardless of how plainly they conflicted with text and precedent. The attorney attempted to walk back his broader claims while maintaining that this particular case involved questions about the original meaning of ambiguous constitutional language that courts should hesitate to resolve when political branches had reached different conclusions. Judge Chutkan responded with a statement that drew on her deep knowledge of constitutional history and her evident concern that procedural doctrines not be weaponized to insulate unconstitutional action from review. She noted that the citizenship clause was adopted specifically to override the Supreme Court's decision in Dred Scott and to establish that courts had been wrong to defer to political branch determinations about who could be a citizen, suggesting that the very purpose of constitutionalizing citizenship was to place it beyond political manipulation. She observed that the executive order at issue purported to reinterpret constitutional text in ways that contradicted over a century of precedent and established understanding, and she questioned whether allowing such reinterpretation to proceed without judicial review would effectively render constitutional provisions meaningless by permitting executive branches to simply announce new interpretations whenever existing ones became politically inconvenient. The government attorney conceded that courts had authority to review some citizenship determinations, but maintained that they should do so with substantial deference to executive expertise on immigration matters, and that preliminary relief should not be granted absent clear, showing that the executive order exceeded constitutional bounds. That was the moment when Judge Chutkan recognized that Representative Crockett had submitted a request to address specific historical claims about the 14th Amendment's original meaning that had been advanced in the government's briefs and repeated during oral argument. The procedure was unusual in federal district court proceedings, where amicus participants typically did not present oral argument, but Judge Chutkan had discretion to hear from amici when their submissions raised important issues not adequately addressed by the parties, and when doing so would assist the court in resolving complex questions. She granted Crockett 5 minutes to address the historical record regarding the jurisdiction language in the Citizenship Clause, making clear that she expected focused presentation of evidence rather than general policy arguments. Jasmine approached the podium with materials that included copies of congressional debates from 1866 and subsequent legal opinions addressing birthright citizenship, her preparation evident in the careful organization of documents tabbed and annotated for quick reference. Your Honor, she began with the formal respect that federal court protocol required while maintaining the confident precision that had characterized her previous legal presentations. The government has argued in its briefs and again today that the Citizenship Clause's language, providing that persons born in the United States and subject to its jurisdiction are citizens, was understood by its framers to exclude children of parents who were not legally present or who owed allegiance to foreign nations. I want to address that historical claim directly because it is contradicted by the actual debates in the 39th Congress that drafted and approved the 14th Amendment and by the subsequent judicial and executive branch. Interpretations that have consistently recognized broader, birthright citizenship than the government now claims. She opened one of her tab documents and began reading from the congressional record with careful attention to providing complete context rather than cherry-picking favorable quotes. During floor debates on the citizenship provision, Senator Lyman Trumbull, who was chairman of the Judiciary Committee and a primary author of the amendment, was asked specifically whether the language would include children of Chinese immigrants who were not eligible for naturalization under the laws then in effect. He responded unambiguously that it would, stating that the jurisdiction language meant subject to the complete jurisdiction, not owing allegiance to anybody else, which excluded only children of foreign ministers and similar cases. She looked up from the document to address Judge Chutkan directly, her voice carrying both the authority of careful research and the moral weight of defending principles she viewed as fundamental to American identity. The government's brief attempts to read the jurisdiction language as creating a broad exception for children whose parents are unauthorized immigrants or temporary visitors, but that interpretation finds no support in the actual debates or in the understanding of the legislators who voted for the amendment. The framers understood that they were creating a clear rule that birth on American soil conferred citizenship with only the narrowest exceptions for individuals whose parents enjoyed diplomatic immunity or were part of invading military forces and thus were not subject to ordinary legal processes. She paused briefly before continuing with an observation that cut to the heart of the government's position. The government's interpretation would essentially read the birthright citizenship rule out of the Constitution by creating exceptions so broad that they would swallow the rule, determining citizenship based on parental status in ways that the Citizenship Clause was specifically designed to reject. Judge Chutkan leaned forward with evident interest, asking Crockett to address whether subsequent Supreme Court precedent had adopted the narrow or broad reading of the jurisdiction language and whether those precedents remained good law or had been undermined by more recent decisions. The question signaled that Judge Chutkan was seriously engaging with the historical evidence and recognized its potential importance to resolving the constitutional question. Jasmine responded by walking through the Supreme Court's 1898 decision in United States v. Wong Kim Ark, which had held that a child born in San Francisco to Chinese parents who were lawful permanent residents but ineligible for naturalization was a United States citizen under the 14th Amendment. She explained that the court in Wong Kim Ark had exhaustively examined the common law background of birthright citizenship, the debates over the 14th Amendment, and the consistent practice of treating children born in the United States as citizens, regardless of parental nationality, and had concluded that the Citizenship Clause embodied the broad principle that birth within the territory conferred citizenship, subject only to the diplomatic and military exceptions that Trumbull had identified. She then addressed what she anticipated would be the government's response to Wong Kim Ark, which was that the case involved parents who were lawfully present rather than unlawfully present, and therefore did not control the question of children born to unauthorized immigrants. Your Honor, she said, with the precision that came from having anticipated and researched every possible counter-argument, the government wants this court to believe that Wong Kim Ark's holding was limited to children of lawful permanent residents and therefore does not preclude denying citizenship to children of unauthorized immigrants. But that reading ignores the court's reasoning. which was not based on the parent's lawful status, but rather on the territorial principle that birth within the United States conferred citizenship, except for the narrow diplomatic and military exceptions. The court specifically rejected arguments that children of Chinese parents should be excluded from citizenship because their parents owed allegiance to the Emperor of China and could never become naturalized citizens under then-existing law. If parental alienage and inability to naturalize were insufficient to deny citizenship to children born here, it is impossible to understand how parental immigration status could provide a basis for denial consistent with Wong Kim-ark's reasoning. Judge Chutkan asked whether there were any cases or executive branch interpretations subsequent to Wong Kim-ark that had addressed the specific question of children born to unauthorized immigrants, and whether the consistent practice had been to grant citizenship or whether there was ambiguity that might support the government's position that the question remained open. Jasmine responded by citing multiple federal court decisions over the past century that had applied Wong Kim-ark to grant citizenship to children regardless of whether parents were present lawfully or unlawfully, and by noting that every presidential administration since Wong Kim-ark was decided in 1898 had issued birth certificates and passports to children born in the United States without inquiring into parental immigration status. She pulled out another document and read from a State Department Foreign Affairs Manual section, stating unequivocally that birth in the United States establishes citizenship, except for children of diplomatic personnel, a policy that had been in place for decades under both Republican and Democratic administrations until the current executive order purported to change it through unilateral executive action. She then shifted to addressing the broader constitutional implications of allowing the executive branch to reinterpret the citizenship clause through administrative action rather than requiring constitutional amendment. Your Honor, if the executive branch can simply announce a new interpretation of the 14th Amendment that contradicts over a century of precedent and practice, then constitutional provisions cease to have fixed meaning and instead become subject to political manipulation based on whichever party controls the White House. The citizenship clause was placed in the Constitution precisely to prevent political branches from manipulating citizenship rules to exclude disfavored groups. Allowing the executive to redefine citizenship through executive order would defeat that purpose and would establish a dangerous precedent that any administration could reinterpret constitutional provisions to reach preferred policy outcomes. She could see that Judge Chutkan was following her argument closely, taking notes and occasionally nodding slightly as particular points landed. Jasmine continued with an analysis that connected the citizenship question to broader principles of constitutional structure and separation of powers. The government argues that courts should defer to executive expertise on immigration matters. But citizenship is not simply an immigration issue, it is a constitutional status that determines fundamental rights in relationship to the national community. When the executive branch claims authority to redefine constitutional citizenship through unilateral action, it is asserting power that belongs to the people, acting through the constitutional amendment process, rather than power that Congress has delegated or that inheres in executive authority. No amount of deference to executive immigration authority can justify allowing the president to effectively amend the Constitution by reinterpreting its clear language in ways that conflict with text, history, and precedent. She paused and looked directly at Judge Chutkan. Your Honor, if this executive order is allowed to take effect, children will be born in the United States who are denied citizenship and rendered stateless, unable to claim the protection of any nation, despite having been born on American soil and having no connection to any other country. That outcome is precisely what the Citizenship Clause was designed to prevent. Judge Chutkan asked what Crockett believed was the appropriate remedy if the court found the executive order unconstitutional, and whether nationwide preliminary injunction was justified or whether relief should be limited to the specific plaintiffs before the court. The question indicated that Judge Chutkan was seriously considering the merits and was thinking ahead to implementation issues that would arise if she ruled against the government. Jasmine responded that nationwide injunction was not only appropriate but necessary because the executive order by its terms applied uniformly across the country and because limiting relief to named plaintiffs would create chaos with some children born in the United States receiving citizenship, while others in identical circumstances were denied it based on the fortuity of whether their parents happened to be connected to the specific lawsuit. She noted that the Supreme Court had approved nationwide injunctions in appropriate circumstances, and that a constitutional violation affecting fundamental rights and status of potentially millions of individuals certainly qualified as such a circumstance. She then delivered a closing statement that brought together the historical, doctrinal, and practical strands of her argument into a coherent whole that would resonate beyond the immediate legal questions. Your Honor, The Citizenship Clause represents one of America's foundational commitments, the principle that national belonging is determined by birth on our soil and acceptance of our laws rather than by bloodline, ethnicity, religion, or the immigration status of one's parents. That principle has been central to how America has integrated successive waves of immigrants and their children into a unified nation despite enormous diversity of origin and background. Allowing the executive branch to undermine that principle through reinterpretation of constitutional text would fundamentally alter the American social compact in ways that only the people themselves should be able to accomplish through constitutional amendment. The executive order before this court does not merely implement immigration policy or exercise prosecutorial discretion. It purports to rewrite the Constitution's definition of citizenship in ways that contradict text, precedent, and our nation's most basic commitments to equality and inclusion. This court has the authority and the responsibility to prevent that constitutional violation, and the historical record and legal precedent provide overwhelming support for doing so. The silence that followed was remarkable not because it was uncomfortable but because it reflected the weight of the moment and the recognition by everyone present that they had witnessed an exceptionally clear and powerful presentation of constitutional argument. Judge Chutkan sat quietly for several seconds, reviewing her notes and apparently considering the implications of what she had heard. When she finally spoke, her voice carried the careful deliberation that characterized her most important rulings. She stated that she would take the matter under advisement and would issue a written opinion addressing both the threshold jurisdictional questions and the constitutional merits, but that she was inclined to grant expedited briefing on the preliminary injunction motion, given the imminent effective date of the executive order and the serious constitutional questions that had been raised. She noted that Representative Crockett's presentation had been helpful in clarifying the historical record and that she would carefully review the sources that had been cited before reaching any final conclusions. She then made an observation that would be quoted extensively in news coverage of the hearing and in subsequent legal commentary about the case. She noted that courts had sometimes been criticized for being too quick to enjoin executive action based on constitutional challenges that might not ultimately prevail on appeal, but that the present case involved an executive order that purported to deny citizenship to children born on American soil in ways that appeared on their face to contradict constitutional text and Supreme Court precedent stretching back over a century. She stated that when executive action raised such serious and substantial constitutional questions, and when failure to grant preliminary relief would result in irreparable harm to individuals who would be rendered stateless through denial of citizenship, courts had not just authority but obligation to intervene pending full consideration of the merits. She scheduled further proceedings and adjourned the hearing, leaving the packed courtroom to process what had just occurred and what it might mean for the future of birthright citizenship and executive power. The immediate reaction outside the courthouse was intense, with immigration rights advocates expressing cautious optimism that Judge Chutkan's questions and comments suggested she would rule against the executive order, while government supporters criticized what they characterized as judicial activism and overreach into questions that should be resolved by elected branches. News coverage focused extensively on Jasmine Crockett's presentation and her systematic dismantling of the government's historical claims, with constitutional law professors from across the ideological spectrum praising the rigor of her research and the clarity of her argumentation. Several noted that her intervention had provided Judge Chutkan with a more complete historical record than the party's briefs had contained, and that her framing of the case as involving not just immigration policy but fundamental constitutional structure had elevated the discussion in ways that would make it harder for appellate courts to avoid the core constitutional questions if the government appealed an adverse ruling. Within 48 hours, Judge Chutkan issued a preliminary injunction blocking implementation of the executive order pending full consideration of the constitutional challenge. Her opinion drew heavily on the historical evidence that Crockett had presented, walking through the congressional debates over the Citizenship Clause and explaining why the framers had adopted a clear territorial rule with only narrow exceptions rather than creating the broad exclusions that the executive order attempted to impose. She quoted extensively from Wong Kim Ark and explained why subsequent precedent had consistently applied its reasoning to grant citizenship based on birth, regardless of parental immigration status. She rejected the government's procedural objections, finding that plaintiffs had adequately alleged concrete injury and that the case presented justiciable legal questions rather than political questions beyond judicial competence. Most significantly, she held that the executive order was not merely unwise policy, but was unconstitutional on its face, because it contradicted the clear meaning of the Citizenship Clause as understood by its framers and as applied by courts for over a century. The opinion's analysis of separation of powers and constitutional structure reflected themes that Crockett had emphasized during her presentation. Judge Chutkan wrote that allowing the executive branch to reinterpret constitutional provisions through administrative action would fundamentally alter the balance of powers and would render constitutional text meaningless by permitting each administration to adopt interpretations favorable to its policy preferences. She noted that the Constitution provided a clear mechanism for changing its provisions through the amendment process, and that the difficulty of that process was a feature rather than a bug, ensuring that fundamental changes to constitutional structure required broad consensus rather than simple political majorities. She observed that citizenship was too fundamental to be subject to political manipulation, and that the citizenship clause had been adopted precisely to place citizenship beyond the reach of political branches that might seek to exclude disfavored groups through creative interpretation of jurisdictional requirements. The government immediately appealed and sought a stay of the preliminary injunction from the D.C. Circuit, arguing that Judge Chutkan had exceeded her authority and had failed to give proper deference to executive interpretation of ambiguous constitutional language. The appeal attracted enormous public attention and extensive amicus briefing from parties across the political spectrum. Constitutional historians filed briefs supporting Judge Chutkan's historical analysis and documenting the consistent understanding since the 14th Amendment's adoption that birthright citizenship extended to children, regardless of parental immigration status. Immigration law scholars filed briefs explaining the practical chaos that would result from creating different classes of individuals born on American soil, with different citizenship status, depending on factors having nothing to do with their own actions or allegiances. State attorneys general from both Republican and Democratic administrations filed briefs on opposing sides, with some emphasizing federalism concerns about executive overreach and others defending broad executive authority over immigration matters. The D.C. Circuit heard oral arguments within weeks given the expedited nature of the appeal and the importance of resolving the constitutional questions before children began being denied citizenship under the executive order. The three-judge panel that heard the case appeared deeply divided during oral arguments, with one judge expressing agreement with Judge Chutkan's analysis, another suggesting that executive deference might counsel against preliminary injunction even if the constitutional questions were serious, and the third appearing genuinely uncertain about how to balance competing considerations. The panel ultimately affirmed Judge Chutkan's preliminary injunction in a fractured opinion that produced three separate writings and left considerable uncertainty about what standard would apply on final merits review. The government then sought en banc rehearing and simultaneously petitioned the Supreme Court for certiorari before judgment, arguing that the case presented urgent questions of national importance that required immediate Supreme Court resolution. Throughout this litigation process, Jasmine Crockett remained actively engaged, working with the legal teams representing plaintiffs and coordinating congressional efforts to pass legislation that would codify birthright citizenship and eliminate any ambiguity about the citizenship clause's meaning. She testified before congressional committees about the constitutional history and the practical implications of allowing executive branch citizenship reinterpretation. She wrote op-eds and gave interviews explaining why birthright citizenship represented a core American value that should not be subject to partisan manipulation. She also participated in town halls and community meetings, where she listened to stories from families who would be affected by the executive order and who were living with uncertainty about their children's status and future. These interactions reinforced her conviction that constitutional principles were not abstract legal doctrines but practical protections that determined whether real people could live with dignity and security. The Supreme Court eventually agreed to hear the case on an expedited basis, given its importance and the ongoing uncertainty affecting families and government agencies. The oral arguments before the Supreme Court would once again feature Jasmine Crockett, this time as part of the formal legal team representing organizational plaintiffs, rather than simply as an amicus participant. Her role in the litigation had expanded as her expertise and her powerful advocacy had earned respect from civil rights attorneys who recognized that her combination of legal knowledge, historical research, and moral clarity made her an invaluable asset in the fight to preserve birthright citizenship. The case would be argued and decided in the following term, with the outcome uncertain, given the conservative majority's general inclination toward executive deference and restrictive immigration policies, but complicated by the strong historical evidence and long-standing precedent supporting broad birthright citizenship. Regardless of how the Supreme Court ultimately ruled, The hearing before Judge Chutkan and Jasmine Crockett's intervention had already accomplished something significant. It had created a comprehensive record of the citizenship clause's history and meaning that would be available to future advocates and future courts, even if the present court reached a disappointing conclusion. It had demonstrated that executive overreach could be challenged effectively through rigorous constitutional argument grounded in text and history. It had shown that judges committed to careful legal analysis could resist political pressure and rule based on evidence rather than ideology. And it had illustrated once again that speaking truth to power required not just courage but also preparation, not just moral conviction but also technical expertise, not just the ability to identify injustice, but also the ability to articulate why that injustice violated specific legal principles that courts were bound to enforce. Years later, when historians and legal scholars assessed this period in American constitutional development, many would point to the litigation over birthright citizenship as a critical moment when fundamental principles either were preserved through judicial enforcement or were eroded through deference to executive reinterpretation. The role that Jasmine Crockett played in that litigation would be remembered as exemplifying the kind of engaged citizenship and expert advocacy that democracy requires when constitutional values come under threat. She had demonstrated that members of Congress could contribute to constitutional litigation not through political pressure or institutional prerogative, but through substantive expertise and rigorous analysis that assisted courts in understanding complex questions. She had shown that defending the Constitution required understanding its history and being able to articulate that history in ways that connected past principles to present controversies. Most fundamentally, she had embodied the principle that constitutional rights belong to the people, and that protecting those rights requires constant vigilance and willingness to challenge power regardless of the political costs or institutional obstacles. If you want to continue following how this historic case develops and how legal battles over citizenship, immigration, and constitutional interpretation shape the future of American democracy, subscribe to this channel and turn on notifications, because we will be covering every development in this litigation and providing the kind of detailed analysis that helps citizens understand what is at stake when courts decide cases that determine who belongs to the national community and what rights that belonging confers.